Good afternoon, everyone. Welcome to the last session of this year of Thursdays in the Metaverse by the Metaverse Chair of the University of Alicante. Today, we will be talking about NFTs in the Metaverse with Larry DiMatteo, our Hurst Professor of Contract Law at the University of Florida and editor of one of the most relevant books that has been written so far about the metaverse and legal aspects. I'm referring to the research handbook on the metaverse and the law, published by Edward Elgar. And today, Larry is going to be talking about the role and regulation of non-fungible tokens in the metaverse. Larry, thanks a lot for joining us in these Thursdays in the Metaverse. It is the last session that we will have this year, so it is glad that we can close the year with you. I would like to remind the audience that if you want to participate with questions, you can put your questions in the chat, and I will, once Larry has finished with the presentation, I will transmit it to him, and we can have a discussion at the end of the session. So, Larry, thanks a lot for being with us. You have the floor.
Thank you for having me. It's at about 10:30 Florida time, so I had to get up a little extra early today. So if I look tired, I am. The title, as you can see, is about non-fungible tokens, and I'm happy to be associated with the Metaverse Chair, and so I was excited when I was invited. The presentation will talk, vaguely about digital assets in general, but then really specializing on non-fungible tokens, how we would protect NFTs, and how they relate to the metaverse and the creativity that would be going into creating future metaverses and how people could protect their creations, which is problematic as it now stands, and I will get into that soon. First, we can see that NFTs have been around for a while. We have the Bored Ape series, as you see on the left, which has been minted in 10,000 units, which seems to be a common number for these types of things, and most of them are minted on the Ethereum NFT blockchain. And in this case, you see what is a golden ape, which sold for about 3.4 million US dollars a few years back. So you're talking about things that may or may not look silly to you, but can also have high economic value. Traditional auction houses like Sotheby's have now an annual auction of digital art. And the figure you see in the lower right-hand corner is actually an avatar minted to be used within some sort of virtual world. So this is just a taste of what we mean by NFTs. And they're nothing more than tokens placed on the blockchain and certify authenticity and ownership. They're different than cryptocurrencies because cryptocurrencies, of course, are fungible. One Bitcoin is equivalent to another Bitcoin, while NFTs are non-fungible, which means they're unique. They're unique digital objects, one of a kind, or at least part of a minted series, just like the Bored Ape. But each individual image or object is unique. And that's what sets them apart from cryptocurrencies. And of course, they share the idea that they're based on blockchain technology. Notice I have the words authenticity and ownership underlined. Clearly, they authenticate that the purchaser of the NFT is some sort of owner. And that's the real issue of my presentation, is what do we mean by ownership of an NFT? The authenticate title, that doesn't equate to actual ownership of the digital object. And I'll go into that in detail. They're unique, and what makes them different also is that they're almost always stored off chain. So even though you buy an NFT on the blockchain, it gives you some sort of rights, of which we don't know what those rights would be without further investigation. But they may not be ownership rights. They might be just merely access rights, private key, public key into accessing this off-chain object. So the idea that they're off-chain really questions the sort of what kind of ownership someone buys has when they buy, let's say, the $3.4 million golden ape. The market has been expanding dramatically from 16 billion in 2021 to an estimated $210 billion in the next 5 years. So it is clearly something that is of importance. And of course, the perspective that I take as a law professor is, how does the law apply to these new things? And from the perspective of the person buying them, how does the law protect me when I buy an NFT? Well, there's what I call an analogical paradox, which is there are different areas of law that can be applied to NFTs, and which one is chosen will really determine what kind of value there ultimately is in these things. They could be as little viewed as something akin to a license, that these NFT platforms are basic contractual enterprises between the creators of the NFT and the platform, and between the platform and creator and the purchasers of NFTs. So it could be simply a contract, a licensing contract, and your rights would vary depending on the terms of that contract. The second area of law that may pertain would be, are NFTs protected under copyright or trademark law? And I'll talk about that a little bit later, but I would say even if the NFT has some sort of copyright protection or trademark protection, doesn't mean that you obtain that ownership of that copyright when you buy the NFT, which is supposedly as marketed a sale of the underlying asset, the digital art or whatever it may be. And it could also be a title to physical objects like real estate and other things, can be conceptualized into an NFT that is then sold. And once again, the sale may not be a sale under law, and the transfer of rights might not be recognized under law. So it's really important at this stage of the development of NFTs that we come up with some sort of, hopefully, a consensus worldwide as how these things will be treated. The United States has basically taken the view that these are investment securities, investment contracts, to be regulated by our Securities and Exchange Commission. The most protective regime that we could apply to NFTs would be viewing them as personal property. And this is what I advocate, the viewing of digital assets such as NFTs as personal property. And that is the initial view of the United Kingdom, in which their law commission has viewed the digital assets like NFTs as something that can be captured by personal property. The problem there is the view of what property is varies somewhat dramatically between the common law system and the civil law system. So the question becomes ownership of what? And let me just see one more thing here. So under the civil law, and of course it varies drastically between the civil law, as a comparative law scholar, I know the great generalizations about the differences between the civil law and the common law, and these are just that, generalizations. We know there are differences among common law countries, and there are certainly differences among civil law in the way of national laws vary dramatically. And they certainly vary in this area, although they all sort of have in common this idea that ownership means rights against everybody in the world, that if you have ownership of something, that ownership pertains to everyone. And even though we know even ownership rights and property are somewhat divisible through restrictive covenants and other things like easements and stuff, the general idea is ownership is there can only be one owner, primary owner with rights. And that's problematic when it comes to NFTs, and I'll tell you that the reason. And the reason is that NFTs are generally marketed as sales, either through an auction online or through Sotheby's and that. And people that buy NFTs actually think they're gaining ownership when in the terms of the licensing, it really retains rights to the creator, rights that we would generally view as akin to ownership. So exactly what do you own or what rights do you obtain when you buy an NFT? And that's the reason why I think that to develop a robust NFT market, we need to treat it as a form of personal property. And I will talk about that in the next few slides. For now, clearly an NFT is a record of title. But record of title, just in real estate, doesn't necessarily mean ownership. So you have some sort of blockchain record that you have the rights to the NFTA or has been transferred to you. But once again, the creator oftentimes reserve rights, and one of the core rights that it retains is the right of control. So really, you have a right of access to that off-chain asset, but the creator or the platform retains rights to commercialize it, for example. Well, the value of something that you cannot personally commercialize, resell, or retain, creative control over, clearly diminishes its value. But since they're packaged and marketed as sales, I think that a lot of purchasers of NFTs are thinking they're getting more than they're actually getting. And I think that the ones that have high economic value, if they're marketed as sales, then the law should intervene to make sure that the NFT purchaser actually obtains ownership rights. Example we can use is digital art that certainly has been sold online and for vast amounts of money in certain cases. The 10,000 picture digital artwork was sold by Sotheby's somewhere around, I think, $57 million, and the Bored Ape market is in the, of course, hundreds of millions of dollars. That's just a taste of what's to come. But if you look at it clearly from a technical point of view, not a legal point of view, NFTs are basically smart contracts put on the blockchain. So from a technical point of view, they're not property, they're contracts. And if we look at the civil law, we see that property must be a thing. So under the German Civil Code 90, a thing would be something that has tangibility, it's physical, it's movable. And therefore, we talk about property rights to things. But when we're talking about non-tangibles, we know that you can have rights to non-tangibles, and copyrights and IP rights is a form of intangible property ownership. So clearly they are well established in the law, but the rights of ownership to objects versus things, objects being, once again, can be non-tangible in nature, presents a major distinction and questions exactly what NFTs are. Well, we do know they are digital property certificates. Once again, that sounds like ownership, but it may not be. But we know from the art world before technology that there would be, you could buy art prints that were numbered, were unique, because you would own, let's say, number 35 of a print that was capped, let's say, at 200. And these things could obtain value because there's only 200 of them in the world, and you own one of them, a unique one of them, because of the numbering. The same thing is kind of true with the Bored Apes. In that case, when you can't put a number on them, then you can say they're unique. And one thing property is all about, at least real property, is uniqueness. And in the common law, we recognize that because in order to get a order of specific performance, generally the test is this unique? Because it's considered, unlike the civil law, an extraordinary remedy. And in that nature, the idea that all real estate is unique in some way, even though it could seem identical to some other real estate, it is spatially different, and therefore it's one of the few examples in the common law that you can get a specific performance order to allow the forced transfer of the real estate. The more unique the NFT is, the more stronger the argument that they should be viewed as personal property. Another way of looking at it is they're mere metadata, but they can be conceptualized as a material thing. People that own them have a certain kind of attachment to them that is akin to the attachment we may have in personal property. And finally, the idea of sale or acquisition. If they're marketed as a sale, which they are almost all the time, either through an outright sale or through an auction sale, then the party buying them, as I've emphasized, has reasonable or legitimate expectations of ownership. But from a legal or technical point of view, that's untrue. And I think that's problematic going forward if we want to develop a robust NFT marketplace. So let's just get a little more detail on the difference between the common and civil law. In the civil law, property is viewed as ownership of an object, an actual thing, which would be akin to that Section 90 of the German Civil Code that only recognizes things, actual physical things, as the subject of property. But we have a much broader definition, the common law, and ownership can be based on relationships between a person over things, and ownership of property extends to both tangible and intangible things. And to give you a feel for that, let me just go to the next slide. You'll see under the American Uniform Commercial Code, Article 9, the definition of collateral, which used to mean things, also, of course, encompass a vast amount of intangible things. So you can use intangibles as collateral to get a commercial loan. And this just gives you the idea of that what was considered personal property has been greatly expanded under American secured transactions law to include anything from promissory notes, all sorts of intangibles like royalty streams, government debtors, healthcare, insurance, consignments, and even claims in a commercial tort litigation. So if you're part of a lawsuit that involves a commercial tort, you could actually collateralize that and transfer over the claim to a bank to get a loan. And so at the end of the day, what Americans and what the common law views as property is much broader, at least from the history, than the civil law. So in the civil law, there's a corporal dimension, a physical dimension, and also this view that the types of property, whether real property, but really what we're talking about is personal property, is limited. And this is the numerous clauses phrase, which means number clause, that the courts are restricted or prohibited from creating new forms of property. While under the common law, since we have such a broad definition of property and ownership, the courts are free to recognize new types of property, such as digital assets. Now, this idea of numerous clauses varies from civil law country to another. In some countries, it's a principle, which means that the courts do have some discretion in this area. Other countries, it's viewed as a hard and fixed rule in which courts have no flexibility in creating new types of property. So if you go to the bottom of this screen, you will notice that we already have a case in the United Kingdom, the Osborne case, in which the court recognized digital assets, and of course NFTs is a digital asset, as personal property. And this comes off the Law Commission report of England and Wales that recommended that the courts recognize certain types of digital assets as protected as personal property. And if we, I just want to go back, it's probably in a future slide, I just want to go back and say in the United States, I want to reemphasize that courts haven't quite gone that far. Right now, the regulation of NFTs would come from the SEC, as I've said, as an investment instrument. But clearly, there is some recognition in the courts that this indeed may also be property, but the case law has yet to develop and lags behind what is happening in the United Kingdom. Under civil law, and not to beat a dead dog, is this sort of inherent distinction between tangible and non-tangible objects. And we now see a 2023 case in Frankfurt involving digital assets and tokens, and the court said that, once again, the German civil code prohibits the recognition of digital assets and tokens as personal property because they're not things in a legal sense. Well, French law is much more liberal in this regard, maybe closer to the common law, in which ownership in certain intangibles is openly recognized. So what is personal property? Well, generally it's attached to the idea of title. NFTs are considered title to the digital asset, but it doesn't necessarily equate to ownership as it would to a physical thing, or if classified as a personal property. On the whole, I guess what we're saying is that in the common law world, our view of property is much more flexible and allows for the courts to expand the scope of personal property, while in the civil law, generally that would take a legislative action, that they are generally not created. Even in more flexible systems like France, it is still probably historically true that new types of property, as they came into existence over time, were recognized under some sort of statutory law. What would be the benefits of recognizing NFTs as personal property? One example is, well, if they do have real economic value, why shouldn't the owner of the NFT, right, be able to use that to obtain lending for projects or for further development? So under American Secured Transactions Law, if it's viewed as personal property, clearly, and even if it isn't, probably could be collateralized and used to obtain a commercial loan. There's a real fear that when somebody dies and part of their estate includes NFTs, that those NFTs may be considered as personal items, not transferable upon death. So to lock down the value for future generations of NFTs, it's best to recognize them as personal property. Third, well, there has to be a law of transfers. Okay, once we recognize NFTs, they're transferred, whether they're transferred under the current system of pseudo ownership or whether they're transferred as personal property. We already have a centuries old or development of sales law, whether in the civil or common law, that would be applicable to the sale of NFTs. So we have this ready-made law that has been vetted over hundreds of years and is efficient to regulate the acquisition of assets. So that would be a benefit. Also, if we basically say that NFTs can only be called NFTs if they are marketed and sold as personal property, this would provide great legal certainty to purchasers of NFTs and would monetize crypto assets in a way that more and more private parties would trust them and would be certain as to their value. And of course, if we want to really develop NFT markets, viewing them as personal property brings that certainty and creates value. And that is, a major premise of capitalism and the creation of markets. Now, as to the metaverse, it's well known that NFTs will play a large role in the development of virtual worlds. At the end of the day, people create their own avatars, they create their own scenery, they create all sorts of different objects. The issue is, do they have any rights to those objects? And ultimately, right now, I would say probably not. The object would have to have some sort of legal identity, so an avatar to be protected would have to be recognized as some sort of legal thing. And once again, that's not the case. The digital identities tied to the user who either created or adopted the avatar. The question is, well, does that creation have rights? Well, we know the answer is definitively no, because we have the European Court of Justice decision that states that artificial intelligence that creates something that normally would be copyrightable is not copyrightable because it needs the author or the creator has to be a human being. And so we see that users have very limited rights to their own avatar. The idea that rights could be recognized would depend on a whole sort of different characteristics. For example, the process of creation. If you go on to a video game or you go into a virtual universe and you use their uh, uh, platform to generate an avatar, then we could say that's probably an AI generated or partially AI generated. It is not very creative or distinct to be protected in any way. A lot of times, the players or users are anonymous. So if you're anonymous, then you really don't have that personal attachment that somebody that is an identifiable user would have vis-a-vis their avatar or things they create in the metaverse. The characteristics of the avatar or object in the metaverse, once again, we would look at, is this something that is purely fictitious, like I create a ape-like avatar, and of course it has none of the features of me. It is just something made up, and therefore that deserves less protection, I would argue, than an avatar or a thing that mimics the characteristics of the actual user, whether it's face, whether it's mannerisms, whether it's personality, or whatever it may be. If it is unique to that user, then you can see some sort of emotional attachment that should be protected by the law. It may not have great economic value, but it certainly has certain emotional value. And next slide. So how do we protect avatars? How do we protect metaverse creations? Well, one thing is to convert them into NFTs. So the creation of the avatar is not a anything to do with NFTs or objects in the metaverse. But you could first create the object and protect it by minting an NFT version of your creation, and then use that NFT in the metaverse. And then you have at least some sort of control over its use. And if recognized as personal property, then indeed that would be ownership, and you would have rights against anybody else in the world that mimicked that or tried to use that, let's say in another metaverse or video game. The problem with copyright protection is that if it is generated, at least partially, by AI, even though a human being created a prompt, and maybe a very detailed prompt, that in and of itself would not be recognized under copyright or trademark law because it's not protected. Especially the more important law here would be copyright law, because that provides stronger protections, would not operate. And these things may not meet the requirements for trademark or copyright protection. They might not be original enough creations to be copyrightable. They might not be distinctive enough to be protected under trademark law. So just because they are somewhat unique and digital makes it seem like something special or unique, they are not in the sense of copyright or trademark law. But then again, I get to the idea that when we have functional metaverses, people have great attachment for their avatars and the things they create in the metaverse. And unfortunately, copyright and trademark law are really based on economic considerations. The more, the stronger a trademark, for example, the more economic value it has. Some trademarks are outright worthless, and generally the ability to sue for trademark infringement is very limited. Well, brand name things of course, are highly valuable and would support a very strong case for trademark infringement. So solutions include recognition of a different IP regime, and that would be an image rights regime, something other than copyright or trademark because of the economics and maybe lack of originality or distinctiveness of the things we create in the metaverse, but still things that should be protected because of our emotional attachment. Therefore, the idea of image rights, which do exist in our law, but I will finish up with that, a broader expansion of intellectual property rights to create these sort of image rights that fall under the threshold for copyrights or trademark protection. So, near the end, I know I'm near the end of my time. Reframing the law going forward. One, digital assets should be viewed as personal property. And let me say this, that there are technical means to make NFT more property-like. That is not legal means, but the technicians that create these platforms and these technologies can make NFTs more property-like simply by, for example, allowing them to be stored on chain, so the NFT owner has not only access to them, control over them within the blockchain. Excuse me. Sorry about that. Got to turn off my phone. And they can also sever the control of the creator. So the sale or auctioning of NFT would be like a real world auction in which true ownership is transferred. What this means is the civil laws approach would have to be modified in order to recognize digital assets as things. And once again, the other fallback, and these can be done at the same time or over time, we can modify IP law to provide adequate protections, or at least in the short term. I'm going to finish right now. My final slide. In the long term, the real world law will need to protect digital identities and virtual property, which they do not do in a meaningful way now. In the short term, protection of creations in the metaverse can be protected by minting them as NFTs and ultimately protected in the strongest way through the law recognizing digital assets like NFTs as a form of property. I will end right there.
Thanks a lot, Larry. Extremely interesting, I would say. You have raised many legal questions that are really interesting, and I've been taking notes, a lot of notes, because it relates with many of the things that I've been wondering since I have started to do research concerning the legal aspects of the metaverse. I have some questions, but I will leave them for the end. We will try to finish at 1:30, so that you are in time for lecturing in Florida. But before we go with my question, there are two questions in the chat. The first one is by Javier Lopez Guzman, that refers to the consideration of NFTs as personal property in the UK by the Law Commission. And he asked whether there is a trend between common law and civil law countries. And he also talked about, or in particular, he asked about China, whether you can see that, whether you can notice that is like 20 some countries that are adopting the UK approach, and there are other countries that are adopting other approach. What is the case of China? Can you have you noticed that already in your research, or is not the case?
I would say that there has not been any sort of real consensus. That we're still at the very early stages, as you could tell by the fact that the English case is 2022 and the German case is 2023. I don't really think there's any real uh, communications between the different countries. This is sort of a matter of national law, and we know that's a problem when it comes to blockchain technology, smart contracts, the internet, or whatever it may be. The regulation is still found at the national level. Clearly, for purposes of value and motivating people to innovate in the NFT area, some sort of consensus would be nice. But if even a group of countries view them as personal property, and these are meaningful countries in the sense of population, wealth, then whether it's China, the United States, and European countries, that would be a substantial milestone in the development of the marketplace. In this case, it's too early to tell. Of course, the Law Commission is not any sort of legally binding thing. It's a soft law in the sense of providing guidance that can be either accepted or rejected by the courts. Ultimately, any sort of consensus would be probably done through some sort of statutory recognition, that maybe some sort of model law that could be enacted by different countries. But, that doesn't always catch on. We know in the area of database rights, the European Union provides database protections, while the common law, and especially the United States, rejects that type of view that databases can be IP protected, and they can only be protected as trade secrets, while the European Union allows you to register and get some sort of protections that are, beyond trade secrets law. For Mr. Guzman, I forgot the full name. I don't know of anything other than, this conference we had in Istanbul, upon which the book you see on the screen here was, one of the few, one of the first. There have been others. It will take time, and I don't think we'll know the answer to that for at least another 5-10 years.
I assume that the ideas that you have developed in your presentation are covered in this book. I imagine.
Yeah. Yes.
Right. That's good.
And everything else. I mean, how does, let's say, the GDPR apply to NFTs? And, so it's the scholars there came from all different areas of law. And we know, of course, that criminal law could be applied and would have to be applied, possibly, if there are virtual wrongs and things that are performed within a metaverse. But once again, the metaverse really doesn't exist in a meaningful way. So all of these things are conjecture, but given the acceleration of technology, these type of conferences and studies, I think, are apropos, because we're going to have to hit the ground running when they do become functional.
Mm-hmm. There is another question that I would like to give my opinion after yours in the chat by James Stewart. He refers to the commission, to the European Commission's virtual world strategy of 2023. In that communication, it is true that the Commission remain absolutely silent on the regulation of NFTs. If I remember well, it talks about virtual worlds, but NFTs is not covered at all. That's absolutely true. So I don't know if you are able to answer this question, but because it concerns the European framework. But I will put the question to you. Do you foresee the emergence of future EU level regulations in this area that may harmonize the regulation in Europe? I don't know, probably other colleagues of you that has participated.
Well,
in this
when we
book.
talk about harmonization worldwide, there's very few entities like the European Union. So harmonization of law within the European Union would, I think, be very important for the health and protection and values of NFTs worldwide. It's just like IP law. If you get a US patent and an EU patent, that's going to probably be sufficient for you to obtain true value out of your creation or invention. So, needless to say, there will be any sort of a real harmonization worldwide, but partial harmonization. And if the EU would take the step to recognize it, for example, as personal property under an EU regime, even though the national civil law system, some of them would still view them as not property, then of course an EU regulation would supersede that, at least once again in a very narrow, limited area of certain digital assets. I can see that happening because other publications or the AI Act is really talking all about Europe being an innovator, a mover in these areas, the center of the world in AI and stuff like that. Well, if you're going to be the center of the world in AI, and then you probably want to be the center of the world on metaverses and NFTs and stuff like that. So as they are recognized as property, let's say beyond the UK and other common law countries, I think there will be more and more pressure for that act to be modified and to recognize NFTs as digital assets subject to that regulation.
And I think there are also two extra elements to take into account. The first is that I imagine that at this precise moment, the new European Commission is thinking about what to do for the next 5 years, because the program of the previous commission in concerning the regulation of digital activities was extremely vast. They did a tremendous job. And now if you think of what is remaining, what else has to be done, probably this is one of the issues. And the second element is that I have read the Osborne case in the UK, the one where the judge considered that it was property, and it is a case about private international law, because the question was about jurisdiction, and then they said that they had jurisdiction, so they applied English law, and that's why they considered it as property. So
Interesting.
I wonder what would have happened if this case, a similar case, not that case, but a similar case, raised the European Court of Justice, and the consequences would be that the European Court of Justice would have to adopt a decision about how to interpret these artifacts, let's call it like that, NFTs. They will have to give to decide on the characterization of NFTs, and that would be a decision that would be compulsory in all the European Union.
Yeah, and of course that's a path, a very good path, or something you picked upon, and I never thought of that in that regard. I guess my comments would be that these NFT platforms like Ethereum and stuff I'm sure after the English court decision, even though English law, at least in sales, is a very common choice of law, that they will not pick English law or UK law as a choice of law in their terms and conditions. That would be my guess, because once again, uh, uh, the idea of treating it as property at this point is maybe too bold a move for some countries. But it's like anything else. Technology moves and law lags behind, which is okay. That's good, because a lot of times we don't really know the problems or issues of a new technology until it's matured. And then we know what the problems are. And maybe that's the best time for law to intervene. But that said, the acceleration of technology is such that this traditional lag of law behind new technologies can't be very long, like as long as it used to be. And so, the idea that the marketing of these things as sales really leads to a whole idea of consumer and investor abuse. They're marketed one way, but they aren't what they are represented. And so I would think the European Union and some countries would eventually want to protect consumers and investors from this type of shenanigans.
Yeah, it's really interesting. Just to conclude and to give you the final word, I wanted to say that I fully agree with your opinion of considering these NFTs as personal property. It is, in my opinion, another benefit that I would add, that is that it will increase consumer protection, because the consumer would know what to expect when they buy an NFT. Certainly, the approach to consumer protection is different in Europe and in the United States, but I think in general we can reach that conclusion. And I think that this is important, and this would be, I will give you the floor just for the final conclusions, that this is important because without that legal certainty, it's impossible to create that is called Web3. I mean, the economic system in the metaverse. You cannot have a market if consumer do not trust in the transactions that are taking place. So and having a common approach in the sense of considering them personal property is the easiest way forward, I would say.
I think you're absolutely right. I agree with everything you said. And I mean, if it's marketed as a sale, you could see one kind of law that could be expanded would be standard terms regulation. If you're marketing it as a sale, then all those terms that retain control to the platform or to the creator would be voided under some sort of standard terms regulation. That would be one way of looking at it also. And
okay,
thank you very much for allowing me into your office and making connection with the Metaverse chair. I wish you well on your project, and I think it's a really important project.
Thanks a lot, Larry. Thanks for collaborating with us. It's been a fantastic presentation. I can tell you, it was in the end a small workshop with all the people that have participated that follows your presentation.
Yes,
and I'm looking forward to collaborate further in the future. Wish you the best for this Christmas.